like all the shows we do, one, we focus on the success story, and today's success story is about the petitioner passing away. Somebody passed away, their dependent children who's waited for the green card for years, can they still get a green card? And we were able to get it for them, right? So that's wonderful. We want to share all the ins and outs and how to apply for this kind of humanitarian reinstatement. The second news topic that we want to really discuss is basically people's rights being stripped away. And so, truck drivers no longer being able to renew their licenses, no longer being able to apply for them. Why? What's this administration doing? How does that affect people's lives? And we're seeing this across the board, not just truck drivers, but that's the latest event that happened. And it's also, we're seeing that with students, we're seeing that with green card holders. And so that's the thing that we want to focus on. While we're talking about all of this, feel free to ask questions. Margaret's going to read it, and then we'll answer and we'll discuss, and we're going to go to 1 o'clock, Pacific time. And then we will cut these videos up into separate little formats, and then we'll post it on YouTube. So, if you miss it, feel free to go back and check it out. But let's start with the news of the day, right? So do you have any relatives that are truck drivers?
No, but one of my friends actually texted me the story because her husband is a truck driver in Texas. So he's a green card holder, and she was, of course, concerned because their whole business and their family relies on this. So I think a lot of people are really scared. There's a lot of confusion out there, and people want to know what's going on.
Right. My uncle is a truck driver, and my wife's uncle also a truck driver. There's several truck drivers that I know in the family. Now, citizens and green card holders, they're still safe. They'll keep their license for now, right? I think that's the big trend that we're seeing. Everybody's rights is being stripped away, right? Right now, you're a green card holder, it's fine. But last week's live, we talked about if you're a green card holder, you can no longer apply for SBA loan. And a lot of these truck drivers, they're independent little company. They're solo practitioners, they have their LLCs. Now they're not able to get an SBA loan. If something breaks down with their trucks, trucks are really expensive. The tires are thousands and thousands of dollars just to replace and just to maintain. And what if you're short 1 month? A couple things need to be fixed. You need an extra loan. Well, if you go through credit card or anything else, it's 30%. SBA loan could drop down a little bit lower, but now they can no longer get it. Right? So green card holders can no longer get SBA loans. People who don't have green cards, people who are on DACA, people who are on TPS, people who are on asylum, they can't renew their truck driving license. Some people have been dedicated, the past 5-10 years to doing the trucking business, right? If you think about COVID, back in that time, they're one of the critical needs of moving the supply chain. They save the day. They help move all the supplies in the U.S. when everything else is shut down. They had extra privileges, but now you're going to strip away their license and not letting them renew, not letting people apply. It seems so almost arbitrary, but that's what we're seeing. And that's just one instance right now.
Yeah, and it seems like this almost happened overnight. Like there was no warning. People weren't able to prepare. So all of a sudden, you just have to pretty much stop working overnight.
Right. And what's next? People who are, what's the point of having a work permit if they're not able to work, right? And why truck driving, right? I mean, you almost think truck driving, you almost think, going to the farm, you're almost thinking these critical infrastructure, they need the most work permits. Like when COVID happened, like nurses, teachers, a lot of people who work in the federal building, people who are in the grocery stores, they were the front line defense. Truck drivers moving everything around when there's a huge shortage on everything. Why take away their work permits? And if it's truck drivers right now, what's next? And why them? That's a part that is kind of bizarre, but we're seeing it happen. One prediction a lot of the attorneys are talking about is maybe everything that's happening in the past year and now is because of the AI boom. And you say, how is that connected? Because of what AI is able to do, because of what ChatGPT, Gemini, OpenCloud is able to do, a lot of the first-year associates, a lot of the college graduates, their first jobs, a lot of those tasks and duties can be done by AI. And so now U.S. citizens can no longer get those jobs. And so there's a huge market shrinkage. You think truck drivers, like, well, AI can't solve truck driving, but autonomous truck drives, autonomous trucks have been in the works for years. Uber was trying to push it out. A lot of other companies are trying to push it out. And once that does happen, 70% of freight transportation in the U.S. are all by truck drivers. Huge amount of them will be out of jobs. And so is it because the new technology is coming, so to save U.S. citizens and green card holders, then they don't allow other people to get it? We don't know. There's no official guidance on to why government is doing what they're doing. It seems out of the blue. Maybe it's calculated, maybe it's not. We really don't know until things happen.
Yeah. I think they mentioned it was something, at least partially, it was because of safety reasons. I guess, in your opinion, do you think it's a matter of safety, or do you think this is more so about immigration enforcement?
I have a hard time believing what I'm reading. Their official response is that, okay, a few truck drivers caused these deaths, and that's horrific.
Yeah.
Everyone's sad about it. But is the right response to that to say, okay, then the entire class of people, all of you don't have, all of you can't renew your license anymore. That just doesn't make sense.
Right.
It's like you target one minority, you target one age group, you target sexual orientation. We know we don't want to extrapolate. We know that justice is not served when you do that, right? When one person does something wrong, you say the entire group. That's fundamentally wrong for society, but that's what we're doing now. So whether you recognize that that's wrong or not, that's what's being done. And does this score political points for this administration to do this, to strip away all of their right to work because of one small population? Not even population, just like 3 instances, right?
Yeah.
I maybe it scores in political points, and maybe this is theatrics, and maybe that's why they're doing it. I think this is giving them sort of the benefit of the doubt, but maybe it's also because they're trying to save jobs, and maybe that's even a better way to look at it. But either way, this is happening, and it's been happening. Student visas, thousands of student visas got canceled just because of the administration decision. And what's worse is that the rhetoric is actually the same. When J.D. Vance, when Marco Rubio, when they're talking about these things happening, taking away their work permits, taking away green cards, taking away visas, the language is actually the same, right? So when we're watching it, it's like the State Department can't decide if somebody has a visa to come into the country. It's by our pleasure that they can come in. We don't have to let them come in. And if they're not being a student, then we can cancel it. Well, they say the same thing about green card holders. If you are a green card holder, J.D. Vance is saying, that doesn't mean you could live here permanently forever. What do you think lawful permanent resident means? It means you are able to lawfully live here permanently, and you can have a pathway to become a citizen. But they're almost saying it as if it's by our own pleasure you can stay. And if we change our mind, we don't want you to be here, then we can take away all your green card. That's not democracy. That's not a rule-based society. That's monarchy. That's just whatever the government wants to do. And that's not right, and that's not fair. And U.S. has some history of that, and it's painfully regretful, and history will look down upon us.
Yeah.
But that's happening right now.
Yeah. Yeah. I guess, do you think that just American people should be concerned in general? Because some people might be like, well, I'm not a truck driver. But how do you think, like, given that there's already like a truck shortage, how do you think it'll impact everyone, essentially?
When you do a deep dive onto this story, here's what I don't like. I don't like the economic arguments of it all. And maybe people want to be practical, and that's fine. But if the only reason you care about this is because your grocery prices are going to be a little bit more expensive, like we're talking about hundreds of thousands of people losing their jobs, losing their company, losing their ability to provide for their family, right? They've been truck drivers. They sacrifice their health, their years to move things in the U.S. It's a hard job. They have long months without seeing their family. They invested all their savings into the truck to maintain it. They deliver things on time so people can have fresh groceries. It's a labor job. They don't make a lot of money. Their health deteriorates. And now because of a few incidents, the entire group of these people all are having their their livelihood taken away. And if the only reason you care about that is because, oh no, now we have a shortage of truck drivers, so that prices are going to go up, so I have to pay $1.29 instead of $1.15 for my banana or for my apple. That is not a good look for America. But all the news articles are talking about it as if that's the only, the economic argument is like the only thing people should care about. I think it's a fundamental moral justice issue, right? It is not a good look for a country that prides itself on the rule of law. If we want to spread democracy, if we want our nation to be a nation of fairness, to be righteous, to make sense, people weren't just granted a work permit. And this work permit, you're not just getting food stamps and easy jobs. People had to apply and qualify with USCIS to get this work permit. And with this work permit, they have to pay for it to apply for it. They go through background checks, and after getting it, they have to invest their own money to build up this own livelihood. It's not easy to just get any truck driving job. And it's not even that glamorous of a job to start out with. And now you're taking that away because you can score some political points. This whole thing just rubs me the wrong way. And the saddest thing about all of it is that it is now a pattern and is only getting worse. Green card holders are being treated like visa holders. Visa holders are being treated like undocumented citizens. Undocumented citizens are treated like they're criminals. Citizens are being asked, are you sworn or are you born here? And if you're only sworn citizen, you might be a second-tier citizen. The rule of law becomes much more of a whoever's in power, gets to decide. This is not a good path that we're on. And I hope most people can wake up and realize the severity of the situation that we're in. And because of the pendulum is swinging, right? And it's swung along on the right side. What happens when it swings back to the left side? Damages are being caused all across this great nation. So order, predictability, not just grocery prices, and its impact on our wallet, but that's why I think people should care about this issue.
Okay, let's see.
Oh yeah, wow.
So the first question I see is it true that now they are issuing notice to appear for visa overstay after applying for VAWA and I-485?
We are seeing that. So if you are a visa overstay, you came in as a tourist visa, and then you apply for 485, you apply for the 360 VAWA. What was supposed to happen, and this was the policy back in 2018, is that once you get a denial, the notice of intent to appear should happen right after or at the same time. That was a policy that they've been wanting to do. They never really implemented. COVID, it was rarely seen. And so that's what could happen, should happen, and some of the rationale behind that is that the government doesn't want people to just turn around and file a second 485. That's what they don't want. And for a lot of reasons, we're not going to go into that. But what's surprising is that we're seeing NTAs being issued before denial, right? So you file the 485, you file the 360, everything is pending, and you haven't been denied yet. Some people haven't even gotten their interviews yet, but then suddenly they get an NTA. And it's scary, right? And sometimes the NTA comes with an ICE check-in. And that's also scary because could you be detained at the ICE check-in and then wait until trial and then go to the NTA trial? What happens with your 45 application? What happens with your VAWA application? Is that going to be terminated and transferred to immigration court? All of that is happening. We've seen it with our own cases. We've seen it in other people's cases. I wouldn't say it's happening across the board, though. I definitely will not say every single case where it's a visa overstay and you file, you are going to get an NTA and you're going to get an ICE check-in and your 45 is going to be canceled and transferred to immigration court. I definitely don't want to say that. I definitely see some of our cases still getting approved without having this fiasco happen. But is it happening? Have we seen it? Yes. What can you do if you get an NTA and you get an ICE check-in? Well, at least this is what we're doing. Other attorneys have also done this. I'm not sure if there's anybody else who's doing something different, but what we're doing is we go to try to close the NTA court right? So we file a motion to terminate this ICE proceeding, this deportation proceeding, and say, hey, look, we have a valid 360 pending, we have a valid VAWA pending, adjustment status. Please just, let us go through the normal channels. We go to ICE check-in and say, please, we already closed the motion, the removal defense case, and so this ICE check-in is now rendered void, and we have a adjustment status case pending. So that's what we've been doing successfully. So thank goodness, don't have to deal with the scare of it all. But if you don't do that, you go check in. Is there a chance you could get picked up? Yes, and obviously it completely depends on why you're getting the NTA.
Yeah. No, I was just going to say, we had a client in this exact situation. She had her VAWA and she had her case preliminary, I get that. Yeah. She had the prima facie approved like 3 times. And then she did get the notice to appear actually on Christmas Day. But luckily we had our attorney represent her in court, and then she was able to schedule the online hearing. So she didn't even have to show up, which, as you can imagine, was a big relief. And everything eventually got canceled. So now she can move forward. But it was a scary thing, and it is happening.
You're right. Cool. So that was a long answer for that short little question. But I need to give context, right?
Yeah. And then, okay, so another question is, can a green card holder travel internationally and come back to the USA without any problems?
Yeah, interesting. The law is 1101, right? CFR. The idea is, as a green card holder, you are not supposed to be inspected upon your entry. You're just like a U.S. citizen. And obviously, this law contradicts everything that J.D. Vance and everybody else is saying, right? But the law's on your side. You're supposed to be able to travel and come back without inspection, unless some of these things happen. One of them is you've left the U.S. for over 180 days. So maybe you were trained by the military overseas, something happened. Well, now they need to inspect you, right? So over 180 days. Very few people leave the U.S. for 180 days for temporary, travel reasons. Some people do. Now, if you have a reentry permit, that's the whole point of you applying for a reentry permit, that you need to leave for a longer period. So if you have a reentry permit, you're safe. If you just have a receipt of filing a reentry permit, you're not as safe. But a lot of officers are generous and nice and understanding. I just came back with a client yesterday, left the U.S. for close to 3 years, like 2.5. Reentry permit expired. When they came in, 3 officers was challenging our client at LAX, talking about, well, why did you apply for SB1? That client was asking me. I was saying, well, because SB1 is like practically a new green card, it takes a long time. It was a big ordeal, but with the entry package we prepared, everything was successful. That client still came in. But that's somebody leaving for like over 2.5 years with the expired reentry permit, And crazy thing, not part of the story, but I think it's also newsworthy. The entire customs system was shut down last night, right? So I was at LAX starting at 4 p.m. The flight was delayed. The client didn't get in until 7 p.m. And at that moment, the entire customs, all the computers were shut down. They couldn't log anybody. And so everybody was being grilled. And it wasn't just LAX. It was all the other customs around the area as well. And so it was a fiasco. And so the officers had to do the traditional method of allowing people to enter. And so I was with the client. The lines were super long. It took like hours to get in. But ultimately still came in. So going back to the question, is it safe for a green card holder to travel? Yeah, if the trip is temporary, if you pretty much live here, if you have filed tax returns, if you have work in the U.S., if you have all these things to prove that U.S. is your home, your travel abroad was temporary and small and innocent, you're fine. But if you leave the U.S. for a significantly long time, right, more than 6 months, more than a year, more than 3 years, then you definitely need to prepare a little bit more to come back in.
Okay. And then another question is, my wife has a removal order. She has DACA and I am an American citizen. Are there any options for us?
Let's say that again. Sorry. Mm-hmm.
My wife has a removal order. She has DACA and I am an American citizen. Are there any options for us?
Yes. Close out that removal proceeding. file for adjustment in court if possible, or get it transferred over to USCIS. Ideally, she gotten an advanced parole. She can leave the country and come back. If in order of priority, I would recommend closing or pausing the court proceeding, getting the advanced parole, activate it, and then file the adjustment in the court proceeding to get it approved in court. That would be the ideal situation. If she's already had advanced parole and she already activated it, then you could just directly file for the adjustment status in the court. And if you can't do either of that, then you might have to do the waiver in the court, if you couldn't get the advanced parole. But there's definitely a solution, because you're a U.S. citizen. And so, yeah.
Okay, and then on YouTube, someone is asking, what would be reasons for national interest exception regarding the 2026 pause for the 75 countries?
Anything important. This is not law, right? National interest exception that's pretty much what it is, right? If you read it, and I've read it multiple times, there's a catch-all, like basically anything that's important. And during COVID, we've applied for so many of these. It's just an officer looking at your case, looking at your situation, and can you convince them? Are they willing to approve it? Now, you need to do some work to prepare for it, and so how can you prepare for it? Recommendation number one is to see exactly what's on the news that's related to your field, right? I'll give you some examples of what we did. Housing crisis is always a big problem in the United States. Affordable housing is always a problem. Our client was in the real estate industry helping solve this problem, and we applied for the EB1 category for this client and the O1 category for this client. And so we argued, well, they need to come in to solve the affordable living situation. This is what they're doing. These are the clients that's waiting for it, right? So look into your background. What do you do for a living? Again, national interest exception is not humanitarian relief, right? It's not a humanitarian parole. So it's not like okay, I feel bad for you and your family, so I'm going to give you a parole to come into the U.S. National interest exception is you're solving a problem for the United States. This could go local to city, county, state. It doesn't have to be the federal government, right? You could solve it for some big companies, right? So if you're working with any of the Fortune 500 companies, if they need you to do a certain project that's really key, a couple letter recommendations can go a long way. So think in terms of that, right? We're always short on nurses. We're always short on special ed teachers, right? So, you can't make this stuff up, right? So look into your background. What is your education? What are you doing? Why do you need to come into the U.S.? How does it connect to the U.S. kind of goal? Prepare for it. Sometimes, like for all the national interest exceptions we do, it took a couple months, right? What are the contracts that you have, the invitations letter you can get, the arguments, and then what's happening in the United States and what news can we pull from the world report? Put that all together, file it with the consulate, make an argument, and just wish for the best, right? It's not math. It's not 1 + 1 = 2. It's an argument. Do your best. There's no harm in trying.
Okay, and then someone is asking, my military parole in place is expiring. If my I-45 gets approved while preliminary PIP is not, what happens?
Your adjustment of status green card application cannot be approved if your PIP is not approved. So what will happen is you're filing for a P1P, it is in process, it is going, and your 45 is going at the same time. Maybe you got into the interview, maybe you didn't. When most likely what's going to happen is your adjustment of status, because it's in the same field office, right? When you file the 45 and the PIP, it's in the same, whether if you're in California, right? It's either District 43, Los Angeles office, Santa Ana office, right? It's the same field office, and most likely it's the same officer. So most likely both applications will be adjudicated by the same officer, and it will be approved at the same time if they're both kind of pending.
Okay, and then I have an approved military deferred action with no criminal record. Am I safe to travel domestically?
I'm assuming, okay, so prior to 2026, 2025, and all the time before, the official answer by all of ALA, by all the attorneys, including myself, I could pretty confidently say is that domestic travel is safe, even to like Hawaii and Alaska, because you're not going to see a customs officer. That is now slightly changed because we know TSA agents, other agents at all the domestic airports are now also sharing travel information with ICE, and they're deputized by ICE to ask immigration questions, meaning almost anybody you meet, a local sheriff, somebody at jail, they all might have the authority to ask you immigration questions. Before they didn't, and they can make determinations based on those questions. And we had clients, Margaret specifically, where they were stopped at a domestic airport and challenged about their immigration status, and our clients were just basically getting ready to like book it and run away. And luckily, everything passed through, and then we eventually got their green card. But if that moment wasn't done correctly, if they got detained by ICE, it would have been a whole different game. So prior to 2025, we would have said yes. Now it's, you might have to be careful. Should be fine. You're probably not going to see customs officers, ICE officers at the domestic airports. But anybody asking you questions, be sensitive, be smart. Don't just openly say things that you shouldn't say. Now, if you have valid status, all this stuff, you're confident, that's fine, right? But in our situation, right, our clients, they weren't here legally. They were in the process of getting a green card, but they could have been detained by ICE. So that was a scary moment.
Okay. Someone else has a question about traveling. They have a DUI, but they're green card holders. So they're concerned and they want to know whether they can go in and out without any issues.
As of now, yes, still. People have been coming back in with a DUI, maybe pull the secondary, ask some questions, answer, that's fine. There is a new bill in the Senate talking about whether or not people who have 1 or 2 DUIs will suddenly become an inadmissibility, meaning their green cards could be confiscated. That hasn't passed into law yet. We're watching that very, very closely. People are hotly debating it. That's one of the bills I'm going to talk to Congress about April when I fly to DC. I really don't think it's a good idea to do that, to make that an inadmissibility. Like at most, make it an offense that is questionable about good moral character, and let the officers determine that later on. Don't make it a black and white rule where if it's 1 or 2 DUIs, automatically your green card gets avoided and it becomes an inadmissibility, because that will be quite bad for a lot of people, and that would be very disruptive. So to answer your question, it's fine now. You should still pull your report. You should be able to explain to the officer. You should explain that you paid all the fines, you took the classes, and you had rehab, and you're no longer a threat. But it is something, what if you're traveling abroad and suddenly that passes, right? That's a scary thing.
Okay, and then a question on YouTube. Is it better to have your criminal case resolved before attending a USCIS interview or afterward with a dismissal? The goal is to minimize the arrest risk.
Right. Almost all immigration attorneys will probably say you should resolve the criminal case before you even file the case, right? Mm-hmm. Most people, including our office, when we take on a new case and we see there's a criminal record, if the probation period is not over yet, if there's a way to minimize the charges, reopen the case and minimize it, right? That's called post-conviction relief. You've already been convicted, but we reopen it to do a lesser charge. A lot of times, all that happens before the case even gets filed. So you're asking, the case is already filed, should I do something before I go to the interview? That's almost, in a way, too late. But if you have to choose one, yes, resolve everything, then go to the interview. I bet a lot of immigration attorneys will probably say it might be a good idea to even withdraw the entire immigration case, resolve whatever that you need to deal with, and then refile. Now, if it's a very small thing like a traffic violation, no big deal. Just pay the fine, and then you can still go to the interview, right? But if it's a misdemeanor offense, if it's a felony, probably want to withdraw and close out the case before refiling it.
Okay, and then someone is asking about emergency advance parole, and whether they're even approving them right now.
Nope, I don't think they are. It's so rare But you could try, right? You go to the info pass appointment, you plead with them, you try. I mean, one of these days is going to be open again. You don't know when. It could be you. But if you're just kind of getting the feel, is it worth doing? We're saying it's almost impossible right now. We haven't heard of any being approved. We constantly try. A lot of them are not. At least the emergency advance parole, in the sense of day of approval, right? You go to the office, you request it, they approve it on the spot, give it to you, right? That used to happen pre-COVID, but that's just, we're not seeing that happen anymore. Now, we just did a case, Rebecca's case. It was less than 1 month expedite advance parole request. That got approved, but that's still 1 month. Normally, what, 4 months, 6 months for advance parole, right? So normally it's a long time. We got it in 1 month, but that, to some people that's still not fast enough.
Yeah, and then someone is asking, their citizenship got approved. They were told to wait 30 days for the oath ceremony, and that's already passed. So they're wondering if there's anything that they can do.
Not much. I would say if it's over 3 months, then it's a bigger concern. The USCIS has to wait on the courts. The courts is backlog, but 1 month to 3 months is perfectly normal.
Okay, and then how long will it take to get I-751 approved after waiting for 43 months already?
I mean, are you able to apply for N400, right? If you apply for N400, because you're married to a U.S. citizen, you could push them a little bit faster. We have seen 751 cases take over 4 years. That's not completely uncommon. Things are just super slow, but you could push them by applying for citizenship and force them to adjudicate both cases at once.
And then someone said, haven't been scheduled for biometrics appointment after 97 days of filing. What should I do?
97 days? That's a pretty
3
long
months.
time for biometrics. Maybe 2 more months, but usually we see biometrics within 3 months. Yeah, so this is slightly longer, but this is an automatic system. So, there's not much you can do. It used to be, there are officers that you can talk to. Now it's all contract-based, all automated. So biometric is one of the things that you have least control over. And definitely don't miss the appointment, right? You can postpone it and then go early, but once you miss it, it's a nightmare.
Okay, and can the immigration judge grant or terminate the removal proceedings at a master hearing?
Yes, the immigration judge definitely has that authority. Don't want to limit their power. Usually at the master hearing is when they're like finding out exactly what's happening. A lot of times they don't, because it's just the initial issues that's surfacing. But I'll give you an example. Our client left the U.S. for a little bit too long, right? And when they were coming back, the customs officer confiscated the green card and gave them NTA, and now they have to go to immigration court. And during this immigration court, they wait a long time before the court. 2 weeks before the court date, we contacted the DA and we said, hey, they're married to a U.S. citizen. They already filed the I-130. Is it okay to cancel the court hearing? The other part, this was like 2 years ago. They said yes, we're willing to support that. So during the master's calendar hearing, we showed the I-130 receipt. We showed that they could just get the green card back. This is a big waste of time for everyone. The government didn't oppose, and the court clerk as well as the judge just closed out the case. So, is it possible? Get the other side on your side to argue? Yes. Now, with that being said, in this day and age, right, 2025, 2026, the government almost never agrees with you. They're supposed to oppose everything you're doing, especially if you're trying to close out a case. However, just last week, our team, we were on call and we heard the government oppose a whole bunch of things, and then the immigration judge just listened to that. It's like, you don't even know what you're talking about. You're just opposing without any grounds. So closed out a bunch of cases. So immigration judge definitely has the ability to do that. It is a luck which immigration judge you're going to get, partially. Our Are they swamped? You can only pray for a fair judge. And closing the case at the master hearing is definitely not something common. I mean, there is a reason why there is a court hearing. But for example, let's say you have a valid case with USCIS that's already pending. It's a very strong case, and there's absolutely no reason why there's an NTA that was issued, notice of intent to appear. The case hasn't been denied yet. Those are some good ones to request for termination. And if the government doesn't have a good grounds to argue, immigration judge might agree.
Okay, and then we have Pearl is asking, will the national interest exemption apply for the 39 countries filing EB2 NIW from inside the US?
If you're filing inside the US, you don't need a national interest exception, right? Because you are already filing for NIW, you're filing for I-140, and then once your priority date becomes current, you can file for 45. The ban, oh, actually, no, sorry. You're right. You're right. You might still want to apply for national interest exception in the U.S. with USCIS allowing you to advance your adjustment status. If you're part of the 75 country, that's only banning visas to enter the U.S. But if you're part of the other ban, where it's much more focused, you still want to argue that that your adjustment status can move forward.
Okay, and next question is, a friend who got her citizenship via INA from her mother is now planning to bring her father to the U.S. She has a U.S. passport. Is she good?
Let me read that. Where is it?
It's this one.
A friend who got her citizenship through the INA from her mother, so her mother got her the citizenship, is now planning to bring her father to the U.S. So my first question is, why can't the mother just bring the father, right? Why does the mother have to bring the daughter and bring the mother? But maybe they're divorced, all sorts of different reasons they don't want to. So the daughter petitioning her biological father, yeah, totally doable. I-130, 45. If the father's in the U.S., if the father's not in the U.S., the National Visa Center and the consulate.
Okay, let's see. I think we got through most of them, but I'm just taking a look.
And if we miss it, just say it again, right?
Yeah.
Because it pops up, you know. Poor Margaret just like juggles so many things all at the same time.
Okay, so on YouTube, someone is asking, what would be reasons? Sorry, I read that one already. Any update on the 75 countries immigrant visa pause?
Like good tidings?
Mm-hmm.
No, and again, bad tidings. I predict it's going to last this entire administration. So we'll see. I know there's like different court cases and people are trying to argue. I'm just a little bit more pessimistic on this front, seeing the trends and everything that's going on. I think what you should watch for is not just when the 75 country ban is lifted. It's more so when is there going to be an update on public charge. Right, USCIS announced it for the N400 citizenship. I think, and I believe, what the next thing is going to be updated for in more detail for the adjustment of status, and then for the consular processing. Once public charge rule is enforced and in place, I think then and only then will the 75 country ban be somewhat lifted.
Okay. Did you want to answer a few questions or move on?
Oh yeah, are there more?
Let's see. Someone, Juan Carlo, if I have a break-like ticket, is that a problem for me in my change of status? Do I have to inform them?
Change in status in going from a tourist to a student or from a student to a H-1B, it might come up and you have to explain. That happened to some of our clients. The cases still got approved, so not a huge concern. They mainly only deny cases if it's like a moral character problem or they just really don't believe you. But if you mean adjustment of status, meaning trying to get a green card, it definitely is not important. So I don't know if you use the wrong phrase, change of status, that's going from non-immigrant to non-immigrant. But if you mean adjustment of status, you know, these minor citations is definitely not an issue.
Okay, and how long will it take for a green card holder's child to get their green card through consular processing?
You want to look at the F2A, F2B category on the visa priority. It depends on which country you're born. It depends on if there's a shutdown, if there's a ban. So it depends on a lot of different factors. If you ask ChatGPT, you can ask it every single month, right? I'm from this country. What is the priority date? This is my priority date. How long does it take for the consulate from this country? And it'll spit out a pretty good answer.
Okay, and then Cassandra is asking if you have an expedited removal in 2010 and then you re-enter the following year in 2011 without inspection, can you file the I-130 from your spouse?
I-130, yes. Everything else, very complicated. So I-130 you can file always, and it's better than nothing, right? Having something filed for you is better than nothing. In the sense of you could at least have something to show ICE or future plans, amnesty. But adjustment of status will be probably very difficult. Waivers will be very difficult, So definitely want to analyze that a little bit more. The expedite removal is just a pretty difficult bar to overcome.
And would you advise premium processing for a pending NIW I-140 now that priority dates are current?
We always do premium processing. There's only like very small number of cases we don't do premium processing. So yeah, we always advise it. Now, talk to your attorney. If they're not ready to help you do a request for evidence, if it comes up, and you're not ready, maybe not a good idea. But you want to be ready. File premium processing. If it comes, you immediately answer it, get that approved, then move on to the next step, right?
And then someone is asking, could someone from the F2A category get a student visa even if the filing has started?
It's not impossible. It is much more difficult. So, let's say hypothetically, you came in as a tourist. You're in the, if you're not in the U.S. and it's purely at the consulate, I highly doubt the consulate will approve an F1 visa for you to come in when they see a I-130 F2A pending. Not impossible, chances just extremely rare. But if you're already a tourist in the U.S. and you do a B1, B2 change to an F1 while there's an I-130 pending, this year it started getting a lot more difficult because the rule change on change of status. Before you meet the basic requirements, you argue that you don't have immigrant intent. Now, we still see a lot of cases get approved, but because of the I-130 already in process, it's much more difficult. And just know, if your change of status fails in the U.S., your B1, B2 also gets canceled, and you instantly become unlawful. So be very, very careful about that.
Do I-526 standalone and I-526E regional center differ in processing times despite being in a rural area, since I-526E requires an approved I-956F?
Absolutely, yep. Different processing times.
Okay, and hi, I was born in Iran. I'm a Canadian citizen. My father petitioned for me in 2016, had my interview in Montreal consulate in mid-2024. I'm on advanced parole for 2 years. Should I file mandamus?
I don't think filing mandamus will help you at all because it's a consulate case. There is a memo from the State Department that says you can use your dual citizenship to apply, and so the 75 country ban and the other ban doesn't affect you. With that being said, administrative processing could take that long anyways, and so they're still going through the review. The best thing you could do is just follow up with the consulate, but mandamus would definitely not help.
Okay, and what's the average time for I-130s? U.S. married Canadian citizen, filed last year in the end of September. Still nothing. My congressman just filled an expedited request.
I would say wait about a year. So September to September is a good barometer.
Mm-hmm. Okay, back to TikTok. Let's see. Is a pause in the 36 countries have been relieved? I guess, has it been lifted?
I don't know, actually. I know the 75 country hasn't, but I don't know about the other one.
And are 42A hard to win right now?
Yes, 42A, 42B, hard to win, but if you have to, just go all in, right? Unless you're saying, do you want to reopen the case and to argue the 42A? That's, and for people who don't know, 42A and 42B is cancellation of removal. It's essentially telling the government, hey, I've been here in the U.S. contributing for so long and I'm so good, Please don't deport me. Please give me back my green card. You have every reason to take away my green card, but I'm so good and I've been contributing so much, so please give it back. That's the argument, right? I lived here long enough. I paid enough taxes. I did all these things. And you can imagine every immigration judge will adjudicate this differently. And every client situation is different. You know, what education you have, what work do you have, how much taxes did you actually pay? Do you have mortgage? Do you have debt? Do you have a company? Do you have great letter recommendations? Every case is different. So, with that being said, if you're stressed about it, then just get to work, right? Everybody does it differently. Our firm does it differently. Other firms do it differently. You're arguing your life story. Nobody can argue it better than you. So prepare for it and make your case, right?
Do you think that Trump will get rid of EB-5 and replace it with his gold card?
Let's start with what he has said and what he wants. He wants his idea to be implemented into the EB-5 program. He also wants his Trump card out because it has his face and brand on it. So he likes that. So I don't think he wants his Trump card to completely replace the EB-5. He wants aspects of the EB-5 to reflect his Trump card, but he wants it standalone. He also wants, let me say that. He also will have a much harder time to change the EB-5 program because he has to have Congress's approval for that. And he's fighting a pretty big uphill battle because to change the EB-5 program will significantly harm a lot of states, counties, and cities, because a lot of states, counties, and cities do really enjoy the benefits of the EB-5 program. Whereas the Trump card and the way he's doing it only benefits the federal government and his face. So with all that context, I don't believe he wants his Trump card to fully replace the EB-5. Practically speaking, however, the EB-5, are there going to be some people who will choose the Trump card over the EB-5? And the answer is yes. And we've already seen a lot of that happen. Certain people, the Trump card makes far more sense than the EB-5 program. A lot of people are still choosing the EB-5 program. You know, we compare the pros and cons. So hopefully that gives you a good context. You know, where I'm talking about this with clients almost on a weekly basis, and I do predict it's going to roll out and become much more of a permanent fixture in the immigration world. I know a lot of people think it might be canceled. I do think it has its place if it can stay.
Okay. And one final question from Parole. This is a follow-up question from before. Will the national interest exception be applied for within the NIW in the same petition?
My recommendation is you can include the national interest exception argument in the conclusion of your EB2 NIW brief, maybe half a page, maybe a paragraph. But after you file it and once the case gets approved, you file a separate national interest exception argument, multiple pages, with your adjustment of status application. So if you're doing concurrent filing, there's the brief for the EB2 NIW case, include a little bit of national interest exception, and then you have your 45 argument, and then you include a national interest exception there. That's where it should really stay. But that's the way we do things. That's the way I do things. Maybe other firms will do it differently. I don't think there's a necessarily right way that you have to stick to. Cool. Yeah, this is a good one. Today's success story is about the petitioner passing away. So our client was a EB-5 investor, invested in this big project back in like 2015. Everything got approved. Husband and wife and also younger siblings all stayed in China still. The eldest was studying in the U.S. Came as a student visa, was studying. Unfortunately, the mom passed away. She passed away very recently. In 2023-ish. She has a whole team of people helping her with the EB-5 project. They don't know what to do. They contacted us. Amy was a account manager working on this case, preparing everything. The 526 was already approved. Everything was already approved, but because of she passed away, everything got closed. So we had to reinstate the 526 approval, which is similar to the I-130 or I-140 approval, and we had to file for the 45 because priority is current now. But here's the situation: the main petitioner passed away abroad. The child was here in the U.S., and the rest of the family is out of the U.S. So the key thing we had to argue was this humanitarian relief under 204 argument. If we can successfully convince the officer that the U.S. is resident, if this warrants humanitarian relief, that the child could get a green card, if the U.S. child could get it, then there's a high possibility that the siblings and the spouse can get it. But if the U.S. child couldn't get it, then nobody else could even has a chance of getting it. So it was a high stakes case. We just got the case approved, I think, like 2 weeks ago. And then once we secured it for the U.S. child, who's a student here, then everybody else has a chance. It's always so sad when situations like this happen. And one of the hardest part about it is your focus is not on your immigration status when your mom dies. You're focused on so many other things. But if you don't take care of your immigration status timely, then it's also, you miss that opportunity. And one of the key things is that, when the person passes away, you have to be in the U.S. You have to make the argument that your U.S. is your residence. And usually we do that when somebody has a valid visa. Now, if you're temporarily traveling abroad and you just fly back immediately, maybe you can still make an argument. But if you're not even in the U.S. at all, it's just too hard to make these type of arguments.
Did this only work because the case was already approved? Like, for example, if the case had been filed and then the petitioner had passed away, would she still have received her green card?
Much harder. So we didn't get too much pushback because the case was already approved. The priority date was just so long, and the child was in the U.S. So when we built up the brief and we made the arguments, it was just focused on the death and the humanitarian aspect of it. But the case was already approved. If the case wasn't approved, if it's still pending, but it's prima facie able to be approved, everything looks good, we will still make the same argument, but it'll be now the officer has to adjudicate two things, right? So if let's say it was a brand new I-130, I-140, 526 application, it still could take years. Well, maybe it'll be a harder argument, But this seems to be. This was the EB-5 case. They invested over $500,000 back then, and the child's in the U.S. studying, waiting for this kind of green card. It's bound to happen, but then the mom passed away, and so, yeah.
Yeah, I was saying in this specific case, it took 2 years, but when I looked at processing times this morning, it said it takes about 100 months. So that's like 8 or 9 years.
Right.
With this specific category, does that mean that you get a receipt notice, and then basically you have to wait 8 years? And obviously, a lot can happen in that time. A lot
can happen, and there's no other immigration category where it takes this long, right? People complain like, "Oh, I'm married to a U.S. citizen. I filed for a green card case. It took me over a year. That's crazy." Well, these EB-5 investors who spend close to $1 million now have to wait that long. Now, that was the old law. The new law is a little bit faster, but it's still years and years and years of time while they adjudicate. And the crazier thing is, if you look at their adjudication manual, how long does it take an officer to review a case? We're talking minutes. We're not talking hours. We're not talking weeks. It's just a person with a computer scrolling through, looking at the application and making a decision, just like any government work, right? Approving a DMV driver's license, approving a work permit, approving an advanced parole, approving a green card. It's just paperwork and reviewing. But in some instances, we're talking years. And a lot can happen. And main petitioners can pass away. But what about all the children, right? The spouse. So I love immigration law in the sense that they think about all these things. I try to study other countries' immigration law as well, just to kind of do a comparison. And in my opinion, by far, the most sophisticated is the United States immigration system. It's the clearest, it's the most transparent. As much as we complain about it, CBP, ICE, consulate, USCIS, rules don't make sense, CSBA calculation, a lot of it is well, at least there are the laws that allows people to freeze their age to allow somebody to still qualify for the green card, even though they're older now. In this case, even though the main petitioner passed away, the dependents can still get it if you make the right argument. And even in this administration, where people's licenses are taken away and people's visas are getting canceled, in this instance, this college student is still able to qualify for the green card, even though the main petitioner passed away. Hard to say that this will apply to any other country, and so you make a good argument. There are still good officers that are willing to listen and approve.
So aside from, I guess, meeting like the core criteria, like being here in the US, having status, probably being in the application when it was filed, things like that, do you usually recommend that people submit additional items, for example, to show good moral character or to show that you would be an asset to the US? Like, I guess I'm asking, like, is it discretionary or is it you meet all of these, like, 5 core criteria and it will probably get approved?
The humanitarian reinstatement, the 204, is definitely discretionary. So because it's discretionary, you want to provide as much as you can. For non-discretionary cases, adjustment of status and a lot of other things, traditionally it is quote-unquote non-discretionary, but we're hearing from this administration and a lot of officers and USCIS memos saying applying for adjustment of status is a privilege, and just because you meet all the requirements doesn't mean we have to give you a green card, meaning everything is discretionary now, right? So there's things that were labeled discretionary. Well, what does that mean? That means it's even more discretionary. So in any instance, it's a good idea to really put your best foot forward, to really present yourself in the best way. Now, when you're dealing with a case, it's not in a theoretical vacuum. You're limited by time, you're limited by energy, you're limited by funds. In this case, you're limited by your grief. The family is suffering. This thing happened, people passed away. It's time to file. You have to focus on school, you have to focus on family. This kid is in the US alone. Father, siblings, all abroad. The grief is real. How much effort can you actually put in to build that application, right? And so because it was a strong case, we built it. We didn't include like as much as we could have. If the 526 wasn't approved yet, if the I-140 wasn't approved yet, if the I-130 wasn't approved yet, we definitely would have included more. But in this case, everything was approved. It's an EB-5 case. They waited for a long time. It was a great student. Been here in the U.S. for close to a decade now, in a way. So we thought it was a fairly strong case. But that's our professional judgment, right? And I think that's the difference between, just doing it yourself. You don't know exactly kind of, what's the parameter. And every office, it's more art than science. Everybody does it a little bit differently. So I mean, you got to see how Amy prepared the whole thing. Beautifully done, well prepared. I mean, I could totally imagine if this case was your case, Gabby's case, it probably be 10 times the amount of exhibits because you want to do that, emotional argument. But you can see sometimes it's not strictly necessary, but in the case, discretionary. You just don't know how much officer wants.
Yeah. I do like what you said about grief because I feel like that's part of the process that we forget about. Even as practitioners, we're like, give me these documents and just pressuring the clients. But in reality, like even when they do the I-601A waiver, a lot of times they're hesitating because they're scared of that interview in Ciudad Juarez. Sometimes when it's, the I-751 waivers, they're in the middle of this divorce. And then now we're asking them to dig up all of these pictures from their loved ones. So yeah, there is definitely like the legal side of things and people having to do things because it's necessary. But it's really hard to also deal with all of the emotional stuff that comes up.
Yep. But that's the work. So we work with the client, we get the things we can, make the best argument, encourage them, and pray for the best. Okay? Thank you guys. See you guys next week. Take care. Bye-bye.